Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Thank you for that stirring cry. And so welcome to today's session of the Appeals Court, which is a single case. It's Wednesday, June 11th, 2025. And I don't have the docket sheet right in front of me, so I've got to get it on my tablet here, which has all of the necessary information. So your panel today is me. I'm Judge Massing. We have Justice Henry. We have Justice Hodgens. As you know, or maybe you don't know, 15 minutes per side. There's no rebuttal, so make sure to get out all your arguments that you can. Like I said, you have 15 minutes, and you're entitled to use it all. There's no penalty for finishing early. We have read all the materials very closely, so we're familiar. You can just jump right into it. As I said, the materials are on our tablets here, so if we're looking at our tablets, it's not because we're not paying attention to you. We're looking at the record material. So I can just call the case, which is, how about Commonwealth versus Randy White, 21P801.
Good morning.
Good morning. Attorney Ennis?
Yes.
Okay.
Yes. May it please the court, my name is Attorney Susan Ennis, and I represent the appellant Randy White. Mr. White was convicted following a jury-waived trial on the offenses of operating under the influence of drugs, fourth offense, and operating on a suspended license on OUI, for OUI. The
housekeeping measure, are you challenging the element of operation?
I did not challenge the element of operation.
No, the Commonwealth raised a question mark, so I just wanted to take that off the table if we can, so that lets us focus.
Actually, just to follow up on that, I mean, because in your brief, in your first argument, you argue there was no evidence of an accident, no damage to the car, no evidence he was operating erratically.
That's true. There's no accident. There's no damage to the car.
So that's not.
It could be a possible operation issue in that case, given the fact that
So you just told Justice Henry you're not arguing operation. Are you or are you not?
In regard to the insufficiency of the evidence, yes, I would be arguing also the operation element of it. Yes.
Okay, so then, I mean, he was found in a running car in the middle of the street, passed out.
Right.
Isn't there an inference that he had just operated the vehicle?
The inference could be possibly made that he...
in the light most favorable to the Commonwealth?
Okay.
So, I mean, okay.
So, I guess we could discuss the expert testimony issue I'd like to probably start off with. So, prior to trial, the Commonwealth moved in limine to introduce the expert testimony of Lieutenant Matthew Reddy of the Lynn Fire Department. The trial defender did not receive any prior notice regarding the Commonwealth's intention to introduce Lieutenant Reddy's testimony, and I did argue the notice issue, the fact that, under Rule 14...
Is the Commonwealth correct that you didn't raise the notice issue until your reply brief?
Well, it is an important issue.
Attorney Ennis, direct question.
Yeah.
Is it true that you did not raise it until the reply brief?
I did not raise it in my substitute brief. I raised it in my principal brief.
And you were given an opportunity to file a second substitute brief, which you declined?
I did not, no.
Okay.
I did not file a second substitute, no. In any event, it is an important issue. I think it's worthy of the court's consideration, and it is related to all of my other arguments regarding the expert testimony, because obviously notice is important. The Commonwealth should do its duty, due diligence, and notifying the defendant of.
But he
what-
didn't really testify as an expert, though. Wasn't he really a precipient witness? I mean, he didn't offer an expert opinion.
Said he was under the influence of an opiate. That requires expert testimony, the
Well,
court is well
there was an
aware.
objection to that, and that was sustained, right? And the question was rephrased, and
But he did, at other times in his testimony, also testify that, that Mr. White was under the influence of an opiate. He basically excluded any other medical condition. He was under the influence of an opiate. He testified about the response to Narcan, and he did testify. And the judge, to clarify, did not really make any kind of a ruling on that objection. She just said, oh, well, why don't you just ask it another way, which was not really a definitive ruling. So we don't know, what she took the testimony for when the lieutenant testified that he was under the influence of an opiate. So the judge never made a ruling. She just basically sort of, I don't know, she didn't really definitively say,
No, she didn't definitively say that it's stricken.
No, exactly. That's my point. Yes. Okay, so, and I'm arguing that the expert, the Lieutenant Reddy did testify as an expert and went beyond his expertise in his testimony, and it was prejudicial to Mr. White's case. He didn't have sufficient education, training, or experience or familiarity with the subject matter of the testimony. He should not have been qualified.
I'm sorry to interrupt you again, but I hate to raise all these appellate rules on you, but there was no objection to the foundation, the 5 foundational factors, to his qualifications as an expert, anything like that at trial, right? The only objection was to the lack of notice.
No, he did actually object to the lack of qualifications at the beginning of trial also. If the transcript does bear out that he did object to the lack of qualifications. He can't testify as an expert. He doesn't have that kind of knowledge. He's an EMT. If you do look at the beginning, prior to the beginning of trial, he does talk about the fact that there was not sufficient qualification of Reddy as the expert, and that was also included. It wasn't just the lack of notice. So, and also the effects of Narcan. He testified regarding the effects of Narcan. He didn't just, he went well beyond his knowledge and expertise in his testimony. I mean, obviously, expert witnesses must limit their opinions to matters within the witness's field of expertise. I am arguing that there was inadequate foundation for the admission of the expert testimony where Lieutenant Reddy didn't have sufficient knowledge, training, and experience to provide any kind of an explanation as to how any response to Narcan would prove that he's under the influence of an opiate. I mean, just the mere, response at some point is not sufficient to just prove the fact that Mr. White was under the influence of an opiate. And
so
also,
are you saying that an EMT who's been in the department for 25 years should be precluded from testifying to the administration of Narcan to a patient?
I mean, he can testify, as the trial defender said, he can talk about, that he administered Narcan, but he can't testify regarding the cause of the response or any causally related testimony, conclusions or opinions.
So he can't testify as to why he administered the Narcan?
Well, even if he did testify as to why, basically he's saying he woke up because of the Narcan because Mr. White was under the influence of an opiate.
No, I'm just trying to understand your argument. Are you saying that he cannot testify as to why he believed it was appropriate to administer Narcan?
He can testify regarding, why he would administer the Narcan. However, his testimony went beyond that and talked about the causal relationship between, the Narcan and the response to the Narcan. It meant that he was under the influence of an opiate, basically was his testimony. He ruled out any other medical condition, which he's not qualified to do. And then he speculated that it was fentanyl, which he's clearly not qualified to do. So his testimony clearly prejudiced the defendant because we didn't have the same, there are other cases, and there were no other cases that either published or published that, have such little amount of evidence to corroborate, the influence of an opiate.
Do they usually have drug paraphernalia or bottles?
Yes, there's an admission, there's drug paraphernalia, there's some kind of, here we don't have any, there's an accident. If you look at the Booley case, obviously this is one of the only ones that actually speak about the Narcan issue. Then there are some unpublished decisions, but there's all other indicia of the corroboration evidence, all other indicia of the use of drugs. There's always something else other than just that mere response to, perceived response, really, because, all the other cases have really strong corroborating evidence, at least some kind of drug, indicia. The admissions, the defendant makes admissions. There's not any cases where the defendant doesn't have this. The evidence in this case is so slight, and you compare it to the other cases, as I said, which speak about the Narcan issue. There aren't really a lot of cases anyway, regardless, that talk about Narcan. But the ones that do, there's other corroborating evidence, and that's why the courts say, well, we're not going to reach the issue. I guess I can, cite the Firth case, which was an unpublished decision. Well, we're not going to reach the issue of whether the testimony was improper because it wasn't prejudicial. In this case, I think we have a significant prejudice. I'm arguing that we have significant prejudice where there was not that other indicia. No accident here, it was just, found on the road, and basically, and then the response to Narcan. There are other medical conditions, I think, that Lieutenant Reddy did say that, could cause unconsciousness, cause these same symptoms of pinpoint pupils and, but he didn't have the knowledge to make that link, to the response, from response to Narcan as, he's under the influence of an opiate. And I also said that he testified as a recipient and an expert witness, which he did, and he improperly implied.
What happens if we say that he had the knowledge to say it could have been an opiate and that he responded to Narcan, but we agree with you that he didn't have the knowledge to rule out other possible reasons why someone would have the pinpoint pupils and the breathing and the unconsciousness?
He wouldn't have enough knowledge for either opinion, to be honest. Either opinion would not be.
No, I understand that's your position, but what I'm wondering is if we don't agree with you, I'd rather get your input than let us wander around without your input. So if we don't agree with you about that he could, if we say he could testify as to why he administered Narcan and that the defendant responded to the Narcan, but if we agree with you that he didn't have enough knowledge to rule out other causes, what happens? What do we do then? Do you think we still reverse?
Yes, because it requires, so I'm trying to understand your question just a little bit better, please. If you agree with.
He's got 25 years as not an EMT, but as somebody who's going out and administering Narcan, who's seeing people who have overdosed, and he sees this person, he sees the symptoms of the pinpoint pupils and the agonal breathing, right, and he's unconscious. Right. And so he says, I do this unfortunately all the time, and I administered Narcan and he responded. That all seems a little bit factual, to be honest, like a percipient witness. But what if so we say he can give all that testimony, but we agree with you that it was not proper for him to say it was an opiate and not anything else. You think we still need to reverse?
If he can't say it was an opioid and not anything else. He doesn't have that kind of knowledge. He can't say that. Mm-hmm. He can't possibly ever say that. He doesn't know what it is. That's just the issue. He doesn't know what it is, and he can't. All he can do is say, I administered Narcan. Okay. He can't make that, as I said, that, the connection between, he's under the influence of an opiate. It's clearly a crucial element of the Commonwealth's case. We don't have any other evidence of under the influence of an opiate other than Reddy's testimony. And, when he testified
can he say that in his training and experience, no other medical condition responds to Narcan?
he can't say that. He doesn't know. He doesn't have any knowledge, medical knowledge. He doesn't have sufficient medical knowledge, basically. I mean, there's a physiological reaction that will happen when, a drug is administered. He doesn't have that. He doesn't even go to the hospital to, confirm the diagnosis. So we don't know. He does say, yeah, I administer Narcan on a regular basis, but he doesn't even confirm the diagnosis. He doesn't go to the hospital and say, okay, this person
didn't your
did
client
suffer
kind of
from the
refuse
influence.
treatment?
Sorry?
Didn't your client kind of refuse treatment?
He did not have any.
He says he eloped.
He did. He didn't stay. But
So I mean, what was Lieutenant Ray supposed to do at the hospital? Anyway,
no, I'm
can
just
let's
saying, I mean, we don't have,
Can I ask you
he
to?
didn't confirm anything. I mean, even,
Yeah. Can we just have a little time left. I want to ask you a couple more things. You make your third argument, I believe, is that the evidence was insufficient under Thiessen, Green, because in those cases there was a specific. They found the defendant was under influence by a specific drug, but the Commonwealth failed to show that specific drug was an opiate. And here there's no evidence of a specific drug, but they do show it's an opiate. And I understand that less is more is sort of an ironic, but isn't it enough under the statute?
well, I mean, I think, as I said in my reply brief, and also in my principal brief, Reddy testified as to fentanyl. So he basically, and clearly nobody took any kind of judicial notice of fentanyl. I don't know, he certainly wasn't able to, he was not qualified to.
Right, but he also testified.
opine on
But he also testified
fentanyl.
opiates, right? He said the evidence, the inference was that he was under the influence of some opiate because he responded to Narcan.
Well, he said that Lieutenant Reddy's testimony, if you look at Lieutenant Reddy's testimony, he said, well, it took him a while to respond. So it took a long time for him to respond,
It's
okay?
administered
So
twice.
It was, no, several.
Okay.
Several. It wasn't even just, so he's like, oh, we have fentanyl now. That's the only thing he said, it was because of fentanyl. Now, I mean, it seems like he ruled out any other opiate besides that fentanyl. And it looks like that's what he opined obviously out of his qualifications, that fentanyl was somehow the opiate. That was purely speculative and purely prejudicial to Mr. White's case, where the judge, even as the judge of the fact finder, was clearly influenced by all of this opinion testimony that Reddy gave, which was, as I said, outside of his.
Okay, I've got one more question for you. You make an argument about the operating after suspension, that the RMV records were testimonial hearsay. Mm-hmm. Could you tell me exactly what was the testimonial hearsay?
So the hearsay was that he was notified of the suspension.
I mean, there's a copy of the letter that did notify him of the suspension. You're not saying that that's hearsay?
Well, the letter was.
It's a business record of the RMV.
I'm sorry?
It's a business record of the RMV, or it's a public
record. But it was
record.
prepared in anticipation of trial.
No, it wasn't. It was sent before. It says you're hereby notified effective 1/3/2019. Your license will be suspended for. Actually, no, I've got the wrong page here, but it's before. It's before the incident. They tell him your license is about to be suspended for 730 days for operating for OUI.
Well, as I argued in my brief, the testimonial hearsay, it says that it's a violation of his confrontation clause.
No, I'm asking you what is the statement that is the violation?
He's notified that he's operating on a suspended license.
And can you tell me where in the record that improper notification is?
I'd have to have the record, but it does say you're notified that your right to suspend,
So
right to operate is suspend. That would be the testimonial hearsay.
So the letter that says, "Dear Mr. White, dear Randy White, why did you receive this correspondence? You are hereby notified." That you're saying is testimonial hearsay?
Yes, I mean all of that is testimonial hearsay.
Okay.
And
I think I understand your argument.
Okay.
Are there any more questions?
Did you challenge at all the Gloucester District Court record, or I don't see a challenge to that?
I didn't make a challenge to
Okay.
that. Thank you.
Thank you. We'll hear from the Commonwealth.
Good morning, Your Honors. May it please the Court, Emily Mello on behalf of the Commonwealth. So I want to address chiefly the two issues that were addressed by my sister counsel, sufficiency of the evidence and the expert testimony. And I just want to make sure that when we're addressing those issues that we're not conflating them, because I think when they get conflated, it becomes a little bit confusing. With the sufficiency of the evidence, we're looking specifically at whether there was sufficient evidence that he was under the influence of an opiate. And like Judge Massing had pointed out, it's sort of odd the way the statute is written in that narcotic drug is defined as an opiate or the derivatives thereof and not necessarily a specific drug. A specific drug was not proven here, and to my recollection, there was no testimony about a specific drug. What Lieutenant Reddy testified was that the defendant was responsive to Narcan and that Narcan is effective only in treating opiate overdoses. And that was, in fact, the testimony. So one question is that testimony sufficient? And then the other question would be, was that testimony permissible? So certainly that testimony is sufficient to prove that he's under the influence of an opiate. The evidence is that, I think this is what Justice Henry was trying to ask Sure.
is that, so there's evidence that he was revived by Narcan.
Correct.
Is that sufficient to show beyond a reasonable doubt that he was that he had ingested opiates?
Yes, I would say so. Well, there's more than that. I don't think that that is standing alone in a vacuum. It's that they arrive on scene. He has the pinpoint pupils. He has the agonal breathing. All of these things that are recognizable to an EMT of 24 and a half years who says that his engine responds to 90% medical calls and that he unfortunately sees opioid overdoses chronically in his area, and that he recognized this in his training and experience almost immediately as a very likely opioid overdose. That alone, of course, would not have been enough. Then he gives the Narcan. He disperses with the oxygen, as he's been trained to do. That does not revive him. He actually has to give him 4 doses of Narcan, and then, thankfully, he's revived and he survives. And I think that that altogether is enough to prove beyond a reasonable doubt. And I would just say...
Did he have the expertise to say it couldn't have been anything else? And it couldn't have been any other medical cause?
I think that that wasn't the exact testimony that he gave, and I also don't think that the Commonwealth had to rule out any other possibility. But he did say that in his training experience, he was aware that Narcan was only used and was only effective in treating opiate overdoses. And I do think that that's correct. That's something that everyone knows. And that is especially something that a 24-and-a-half-year EMT working in an area that responds to, unfortunately, opioid overdoses every day.
So how would you answer Justice Hodgens' question? Was he testifying as an expert or as a precipient witness?
He was testifying as both, and I know that that is allowed but frowned upon sort of by the court, and I would say that here I would just remind the court that this is a bench trial, and also that so the judge would be able to kind of separate that out. And also, even in front of a jury, the one thing that the court really looks to when someone is an expert and a precipient witness is that that testimony is explanatory rather than conclusatory. And his testimony was. he did not opine that the defendant was under the influence of an opiate. And when that question was asked, the judge did ask the prosecutor to rephrase it, and I understand that she didn't exactly say, oh, well, the testimony is stricken. But again, there was no jury. I think we can infer that she was saying, we're disregarding that, you need to ask a different question.
So you said he was partially testifying as an expert. Which part of his testimony was the expert part?
I think the fact that the things that he saw about the agonal breathing and the pinpoint pupils, things like that, saying that those were indicia in his training and experience of an opioid overdose. And I think also saying that he had worked 24 and a half years as an EMT and that he responded regularly to opioid overdoses, and this is what he always saw, and that when he gave the Narcan in the way that he had been trained to do, that the defendant was responsive.
But your response puzzles me a little bit because
it's also an observation, I agree.
Well, yeah, I mean, witnesses can bring some level of their own, training, experience, knowledge, and so forth without converting them into an expert witness. I mean, this happens all the time. If you have an ER doc who comes in and testifies about how he or she treated a gunshot wound of someone who came in, are you saying that the Commonwealth should bring in an additional witness who wasn't the treating physician to discuss the medical terms, the technical terms that are being used? That doesn't seem to make too much sense to me.
Right, and I agree with you, and I think that sometimes we get a little caught up in the language of saying, is this person an expert? And I think that someone he has knowledge that can be helpful to the fact finder, that may be beyond an average fact finder. I don't think, does that make him an expert? He's not an expert in the sense that you're bringing in someone completely from the outside, because yes, he was there. He was the treating EMT. I'm not sure that it matters so much. He had the qualifications, and he explained what he saw, he explained what his knowledge was, and he made no conclusions about the defendant's guilt. I'm not sure what the prejudice was or what was outside of where the issue is, essentially. What part of that is not permissible, I guess.
Well, do we have a sense, and I'm just exploring the topic because
Absolutely.
I hear you. Any one of us could also testify about what happens when someone, does Narcan, because we've heard these cases. But, I don't know how long it takes to administer 4 doses, and I do know people lose consciousness, and then if enough time goes by, sometimes they regain consciousness. So I'm just trying to understand, do we know how long it took him to administer 4 doses of Narcan?
The ambulance records were admitted.
They were admitted?
Yes.
Okay.
And that is in my, all of the exhibits are in the supplemental record appendix, yes.
Okay, I know, actually, I do want to ask about the certification, but before that,
Sure.
what about this irony that the less is more, and it's what trial counsel even argued, is that I'm not going to say what specific drug it was, I'm going to say it's an opiate.
It's the way that the statute is written, and so when we go about proving these cases, if we do prove a specific drug, we have to sort of backtrack. If we do, and that's sort of what you see in cases like Green and Thiessen, if you do prove codeine or fentanyl or heroin, you have to then you have to either have the court take judicial notice, or you have to prove that that is in fact an opiate. What you have to prove is opiate. That's just the way that the statute is written.
So But are more questions about
I do have a couple
okay,
of
go ahead.
questions.
On the OUI part?
Oh, on the, nope, you're good.
Okay, all right.
Well, let me, actually, one question. Do you agree, I didn't see you reference the standard of review, so, and I think it's a little confusing, on Lieutenant Reddy's testimony as to whether he is an expert, do you agree that the standard is prejudicial error?
I would say it's abuse of discretion. It's whether the judge abused her discretion in allowing that testimony in.
Is it preserved?
I think the notice issue was preserved.
What about the expertise issue, the qualification?
I don't recall an exact objection to his qualifications, but if it's there, I wouldn't stand in the way. I apologize. But I would ask the court to review under abuse of discretion.
So I do think there is one piece of testimonial hearsay in here. It's on the certification page from the registrar, which is it's page 17 of the appendix and 47 of the record of your supplemental appendix. The first paragraph, I certify these documents are true copies. That's fine. That's the statute allows that. The second one, I hereby further certify that there has since been no reinstatement of his or her license. That's a statement, a testimonial statement for the purpose of evidence in this case. Do you need that evidence to sustain the conviction?
No. So again, in a jury trial, that would be redacted. In a jury trial, as you can see, I've reproduced these exhibits in here, redacting PPI, but as they appeared at the trial. In a jury trial, that would be redacted, that portion of the attestation.
Okay. But so you don't mean the evidence that it wasn't reinstated isn't necessary for you to prove the case?
No, because I apologize, maybe I'm not being clear. So the part that would be used to prove the case is the notice, the contemporaneous notice that was sent on December 24th, 2018, notifying him that effective January 3rd, 2019, his license to operate a motor vehicle would be suspended for 730 days. The judge did note, and I believe it's on page 72 of the transcript, she actually said, I'm not going to consider anything that was in these RMV records that's after the date of the offense. So normally in a jury trial, everything that was after the date of the offense would be taken out. And also, that portion of the attestation that makes that legal conclusion would be redacted. Here, this is a bench trial. There were no redactions made to the RMV records. The judge is assumed to consider them for their proper legal purpose, and the judge is assumed to have considered that contemporaneous ruling for the legal conclusion and not the attestation clause itself. Does that answer the question?
Yeah.
Okay, thank you. If there are no further questions, I will rest on my brief.
I just had a couple of questions.
Oh, absolutely.
So the defendant argues that the RMV mailing certificates dated as received on December 31st, 2018, but the notice is dated a week earlier, the 24th, and also that the certificate of mailing does not indicate what documents it certified is mailed. Do you have a response to that?
Let me just call it up. I believe it's page 92.
I think we're talking about 94 would be the mailing cert confirmation.
Yeah, I mean, I think that the case law in Parento and McAvoy and Royal all suggest that this exact certification is more than sufficient, so I'm not sure what the issue would be.
And then on the issue of the colloquy or not of before the second trial, am I correct that the state of the record is there's no transcript?
So the state of the record is there's no transcript. there was a 45-minute gap in the FTR, and that was why the Commonwealth moved to stay the case and have the record reconstructed. And the trial judge made findings of fact as to that colloquy, and that was what was relied on in the Commonwealth substitute brief.
So the finding was that there was a colloquy, correct?
That's correct. And those findings are in the Commonwealth supplemental record appendix.
So she, though, argues, and this is why I'm trying to understand the state of the record, because the job's hard enough when we all agree on what the facts are, but when we don't know what the facts are, it gets very complicated. So she's saying, and I don't know whether this is correct, that there was a form the judge should have signed, and we don't have that either. We don't have the colloquy, and we don't have the form.
We have the form. The form is signed by the defendant and the defense attorney, and the judge found that the fact that she herself did not sign it was an oversight, that she did in fact give the colloquy, and that she then did not sign the form, but it was signed by the defendant. I mean, she didn't find that it was signed by the defendant and the defense attorney. It is.
Could you give the record site for where it is, where the signed by the defendant?
If you give me one moment, that might be in that.
2 moments.
That is in. That is page 13 of the Commonwealth's supplemental record appendix.
And can we tell if this is with respect to the first part of the trial or the second part
No,
of the
that's
trial?
the subsequent offense portion of the trial. That is the form that was signed by the defense attorney and the defendant and not signed by the judge.
Any more questions?
Does the prosecutor remember that there was a colloquy before the second trial? Do we know?
There was no independent memory in the record from anyone. All we have is the findings of the trial judge.
All right.
Okay, so thank you both. The case is submitted. I just want to say, Attorney S., we might have been a little rough. You raised a lot of issues, and we had to get through them. And but you did it. We appreciate your zealous advocacy for your client. So, with that, we'll be in recess.